Dear colleagues, please take your seats. And special request to our panelists, please take your seats.
Отже, як і обіцяли, продовжуємо роботу конференції. І зараз хочу запросити на цю сцену спікерів і спікерок наступної подіумної дискусії. Вона буде присвячена темі реагування та документування.
So we are starting our second panel about documenting GBV crimes. And I would like to give the floor to Larysa Denysenko, who is going to moderate, and also Oleksiy, Tsvetkov, Tetyana, Ishchenko, Iryna, Shurkhno, Natalia Marchuk, Nadia Stefaniev, and Martin Hackett. Please take your seats. Thank you very much, Iryna. Dear colleagues, I will be grateful if you can give me your attention and focus. There are a lot of us, so if you speak even a little bit, it makes it pretty noisy, and if you are on the panel, so we need to concentrate. So let's start the second discussion. And if the first panel was more about some markers of justice, standards that we are trying to reach, and markers that we use to develop our justice system and legislation, the second panel is about documenting and response to GBV and survivor-centered approach. And we build the panel in the way that we see how the whole system works and how different institutions can coordinate their work, because we'll talk about prevention, pre-trial work, on the procedural steps, public support, about free legal assistance, because usually victims of domestic violence, they have the right to have the legal assistance of first and second levels. And so we need to create tools for them to get these legal consultations and assistance. And then we will also talk about some issues that courts face, how they need to solve basically as if it was some complicated crossword, because when the trial starts and when we look into the issue of burden of proof, it's very important to work on this, but it's also important to find the balance. Not to burden the victim, including emotional burden, but at the same time to keep the balance for offenders. And we will finish this panel with international analysis, so that's how we are going to move. So the first I would like to give the floor to Oleksiy Tsvetkov, Deputy Head on Pretrial Department, National Police of Ukraine, Colonel. So Mr. Oleksiy, let's focus on pretrial. So what happens when we talk about survivor-centered approach? What we need to improve? So we all work in the field, we all work with this area, and we all have a lot to say. So please, up to 7 minutes. And because I do hope that we'll have time for question-answer session. Thank you. So can you hear me? Yes, the mic works. Thank you very much for this opportunity. I would like to thank the organizers of this event and you, Ms. Larysa, for this good question. And I would like to start with the head of the National Police already mentioned that, and the Deputy Minister mentioned as well, that over the past years we have more and more documented facts connected with GBV. But something happened to our mic. You had like some sixth sense that something was wrong with this mic. You probably had this intuition of investigators. So, okay. So, why we have more cases, and I will talk more about investigators' work. But overall, this is the issue that we focus a lot on in the National Police. But the investigating department, we provide trainings for our investigators. Just last week, we had cooperation with the Office of Prosecutor General and local prosecution. We organized training in the west of Ukraine for local offices of prosecutors. They discuss all the issues that they face when they work with GBV. We also invited representatives of the justice system, and so we heard about the issues and challenges that the judges face. And if at first some participants were a bit skeptical about the training itself and the results, but at the end everybody was really impressed. They understood the issues and challenges, and they started to work on possible solutions. So with support of the Government of Canada, we are planning to continue this work next year. And as a part of my speech, I would like to focus on 5 main areas that investigators face when they work in these cases. But before I mention them, I can say that I would like to separate GBV investigation. These are more obvious. So these are the cases when they were registered. No, so we have like the type where we don't know the perpetrator. So usually these are the cases when, for example, sexual violence was committed by a stranger in public place, in the street, for example. And with these type of cases, we need to find the offender. We need to collect enough evidence so that prosecutor and judge accepted them, so that the offender is brought to justice. And other case, these are the cases when we know the offender, and this is the type that we work every day with. So that's about I don't know, we've never done any research, but by my feeling, that's about 70% of all GBV cases when the victim and offender, they know each other. And they had certain history of relationship. They could be member of the same family, or they can live in the same space, or they are friendly. And take into account the history of their relationship. They also have history of their conflict. It can be on everyday life, property conflicts, and so then the process of investigation, that's the cooperation investigator, prosecutor, and the judge. And so each of these party on their level, they can evaluate the evidence collected by the police, which can be accepted or not accepted, to bring the offender to justice. And as these relationships are quite private, so usually there are no witnesses. There is a victim, and there is a person who committed this violence. So that's the first challenge. That so we work with these issue. We cooperate with the Office of Prosecutor General. We have really successful cooperation. I think my colleague from this office will confirm that. So we cooperate to work on this challenge. And also, we need to have cooperation of other institutions which are involved in fighting and preventing GBV. If I'm not mistaken, that's Article 16 on creating the unified registry of domestic violence cases. Unfortunately, it hasn't been created yet, but if we talk about the work of investigators, we believe that this registry will be really useful for all parties. We could use all the data from the registry so that we can prove that the offender systematically commit certain crimes, a certain level of violence. And we can also use those who are working on this registry, we can engage them as witnesses, and also we could use certain documents which are part of this registry. But also other institutions on some social services or Ministry of Education, they can use this registry to provide assistance to survivors. And this is extremely relevant, and we need to create this registry as soon as possible. The next challenge, that's we don't have unified standards how we can prove that domestic violence is systematic. So everybody who works with this issue, so we know that if we talk about the law in Ukraine on we don't have a law how to prove that these actions are systematic. We have only decision of the court. It's Article 173. And Supreme Court stated that the fact that it's systematic, so the Supreme Court stated that it can be proven by police protocol, not only by the ruling of the court. And taking into account the Ministry of Internal Affairs in order to solve this challenge, we, the Ministry, Prosecutor General and Investigation Department, so we work together and we develop draft law where we will give a definition to systematic, like how to prove that it is systematic, and also certain definitions connected to domestic violence. Then the third challenge that investigators face, so that's Article 55 on Istanbul Convention, which states that the country which ratified the convention, that justice should know on whether the victim reports to the police. Unfortunately, we have Article 471, which includes domestic violence and physical violence of minor and middle level of physical violence, and also sexual violence. So these are still the crimes which require the victim to report to the police. And if the victim doesn't want to do that, the police cannot do anything else with this. And even if the victim reports to the police, if the victim decides to drop charges, if they refuse to continue all the proceedings, then we cannot collect evidence which we can include into the case in order to go to court. And we already tried to to change the approach among investigators. So if we get this report, the investigators need to do all the necessary proceeding as soon as possible, to do it within 24-48 hours, to have all the necessary collection about physical damage or physical violence. And to be short, I understand that I take a lot of time. Then about restraining documents. So yes, this year, this part 194, and we describe these restraining documents, but statistics is really bad. We don't use this measure enough. And over the past months, since we focus our attention on that, statistics has improved. But unfortunately, it's not on the level that we would like to see. And in our vision, that any offender who commits domestic violence, some restraining measures should be used. But unfortunately, it is extremely formalized step. So the investigator needs to come to the prosecutor, then it should be approved by the judge, and the suspect sometimes doesn't come to the judge because of some objective or subjective reasons, and so it takes a lot of time, and we cannot protect the victim promptly. And so with the support of the Office of Prosecutor General, we ask them to improve the situation, how we can use these restraining measures better and more promptly. And I hope that next year, the Ministry of Internal Affairs will make necessary changes and will offer the draft law to the Parliament. And one more challenge, and it will be last, and I will be happy to answer all your questions. This additional traumatization. So everybody knows that when we investigate this type of cases, usually the victim has to tell the full story about violence 2, 3, or 4 times. So we have that's the conversation with the police, prosecutor, judge, medical expert, and our vision. We started working on this in 2020. We demanded from territorial department to use this approach with kids who became victims of sexual violence. We demanded to change this approach, and it was hard to start, but more and more often, children, especially in 8 regions where we have barn house approach, they can use the approach of video recording so that it does not re-traumatize the victim. But we understand that our criminal procedure code it protects the rights of a suspect rather than victim. And we understand that if the defendants requires, then the victim will have to be interviewed a few times. And I understand that on the level of experts, it is actively discussed about changing the approach so that it's only one interview with the victim. Maybe we can use common interview of prosecutor investigator and then using video recording for further investigation. Or maybe the investigator and the judge they can investigate only once. So we need to have clear norms about that to reduce the number of this interview, and this way we can protect the rights of the victim. Thank you very much, Oleksiy. When microphone didn't want to work with you, he just hinted that Mike can be tired. Yes, so you took quite a lot of time, that's true, but you emphasize extremely important issues. And basically, you highlighted all the points which we are going to discuss here. And so now the next speakers, you can maybe expand or add, but not to repeat what Oleksiy has outlined. So thank you very much for this very powerful introduction. So now we will talk about prevention, because it's very important when the police come to the call, what they see, what they notice, what they need to pay attention to, how to analyze the risks. So what they need to collect, what kind of information they need to collect, and what the challenges they face with documenting. So I'm giving the floor to Tetyana Ishchenko, Deputy Head on Prevention of Domestic Violence Department, National Police. So Major of the National Police, so Ms. Tetyana, so you're really impressed with all their different positions and responsibilities that you have. So dear participants of the conference, domestic violence globally is the most common violation of human rights. Modern society actively fights this notion. But of course, it's a very difficult task. And one of the priority for the National Police of Ukraine, that's combating domestic violence, prompt responses, and prevention. During the war, domestic violence is even more acute and important to work with. So National Police got 20% more reports on domestic violence in comparison to the previous year. So if we analyze statistics, so every day we receive around 800 calls about domestic violence to the National Police. Of course, the situation of domestic violence in our country, we need to be objective. When we talk about it, we need to take into account whether it is near the front line, whether it's temporarily occupied territories, also the huge number of internally displaced people and war migrants. And I would like to emphasize that in the territory near the front lines, on territories where which are under constant shelling, it's very complicated to respond promptly. And some victims of domestic violence, they don't report to the police. They tolerate this, and they believe that the country has more important issues.
It's also important that over the recent years, there has been real improvements in Ukraine in countering domestic violence, from legislative changes and much more active position of national police that aims to increase the rate of response. In particular, the police officers within their competence are filing reports, filing administrative indictments. There are temporary temporary bans, and regarding the perpetrators themselves are listed in all kinds of medical coverage, and then the pretrial investigation list is also populated with this case. Over the 2 years, the National Police have created 2 specialized units to counter domestic violence. I'm confident that the attendees in this event know something about the results of that work. Currently, we have 54 such units, 62 mobile groups to respond to domestic violence. 10 sectors were created this year. These departments have proven their efficacy in battling domestic violence, so therefore we're planning to create the same units in other regions where there's a high need in that. But there are also challenges and problems during the response to domestic violence. So first and foremost, it is how ready the victims are. Concealment of the fact of violence by the perpetrator is often an indicator of latent domestic violence, and mostly why the victims are hesitant to go to police or even remove their filed complaints, because they are afraid of the threats of the perpetrators. Plus, the police, during their response to domestic violence cases, they contact at the same time with different players in that situation, that different emotional states. The perpetrator can be very much negatively attuned and fearful or enraged. And so the police officers at this situation have to do an assessment of the situation, the legal codification, whether it's about administrative infringement, Article 153.2 of the Criminal Code of Ukraine, or is it a criminal offense, as by Article 126.1. Therefore, using the necessary steps to stop the infringement and, if possible, if needed, provide the medical or psychological assistance to the affected people. Also, it's worth noting that sometimes there are cases of removal or cancellation of the distress call. In that case, the police officers still go to the scene, in any case, to establish the situation. They do risk assessment in every such situation. So how possible is the repeated offense? What are the chances of severe trauma or even lethal traumatization? If the victim refuses to file a complaint against the perpetrator, and if the security level upon the assessment is high, then the temporary detention or temporary ban is issued. The monitoring is established to prevent the secondary offense, and the temporary limitations of their rights and certain duties are then also mandated because of the offense. Also, I'd like to say that battling domestic violence is the task number 1 for the national police now. So we're trying to be more serious in that, to keep the interested parties protected. So we come back to private and public indictment. How the affected person who is under pressure maybe and would be reluctant to continue the litigation around the crime committed against them, and without their official complaint we cannot move any further. So around communication, another important aspect, that sometimes a person affected by domestic violence can demonstrate not only fear, not only be silent, but be very aggressive at the same time. But that doesn't mean that there are less risks where the victim is resorting to aggression, because we can see different expressions in life how people respond to violence against them. And not all people are so submissive. And so what does the Prosecutor General think about all that? Iryna Shurkhno will tell us, the head of the unit of procedural proceedings, of pre-trial investigation and public indictment in criminal cases related to domestic violence, the Office of Prosecutor General. Thank you. So it's a very timely discussion to talk about the problems that law enforcement is facing. And so out of these 2 days of conference with solutions and standards in investigation of criminal offenses in this category, I want to dwell on the problems that we deal with. One of the biggest challenges that criminal justice faces is battling stereotypes and biases in society. Most people still think that domestic violence is an internal problem of that household. They believe it's a problem within the family, and there's no need to put it outside. And so they are hesitant to go to police with claims. But there's also cases where the stereotypes and biases are also present with the affected people. So if they file a complaint to the police, then they get, instead of protection, they get dragged to interrogations time and time again. They get called to the precinct time and time again for no obvious reason. They see that as an overt injustice. So they remove their complaint and they go back home where the violence continues. So we gotta get the balanced response from the police as well. And what my colleagues also hadn't mentioned before, first of all, sometimes the response to domestic violence comes too late. And the measures to stop it also are too late, which leads to victims dying. So in Odessa region, a husband was systematically abusing his former wife, but she filed complaint after complaint. Nothing was done. No administrative or criminal liability was applied. No special bans were applied. No limitations were applied. So he was free to go. He was free to do, but then he used firearm and actually shot his former wife. So with no stereotypes and biases, we should approach and respond to these cases. Second problem that I would like to voice is that we should see how connected the criminal offenses with the domestic violence when we establish legal qualification. Like in Chernihiv region, the perpetrator was systematically abusing his partner, was held liable an administrative offense several times, but when the criminal offense was registered, no previous cases were accounted for, so no limitations were attached. So the perpetrator committed repeated offense, killing his partner in the process. Thirdly, when the investigation is happening, we need to establish the situation and the scene, what are the indication of domestic violence, so that the court cannot dismiss this case when the victim refuses to pursue further remedy, because criminal offenses to domestic violence cannot be dismissed, even if the victim wouldn't like to continue. Fourthly, some statistical data. Unfortunately, failure to act, in our case, undermines trust from the affected people. They don't feel protected. Because bringing the culprits to justice is also prevention. Only in 3% of criminal cases the subpoenas and detention were used. And it's a problem. 5, we need to raise awareness of affected people and the whole population about the dangers of domestic violence, and that victims are eligible for free legal assistance. Because in 3 years, we established that only 2% of victims were provided proper free legal assistance, and that has to be improved. Number 6, we need to use more actively probation programs as established in prevention to domestic violence. Probation is there, but the percentage of courts using it is measly. And we need to apply coordinated action. I'm not going to dwell on that. That's tomorrow's topic. But we have to approach it in a balanced way and use unified approaches that the General Prosecutor mentioned today in the beginning. I want to dwell on them a little bit. First of all, protection of confidentiality of the data of the place of residence of the victim, the personal data, prevention of secondary traumatization, repeated offense, to minimize the interrogation and interviews with victims. In most criminal proceedings, the interrogation of a victim is one of the key sources of evidence, but it shouldn't be abused by the law enforcement. You have to be empathic when talking to the affected people, understand what their state is, how difficult it is for them, so they are able to talk to you, open to you. So, and acting properly to prevent undermining the trust. Using Article 225 Criminal Code is not prevented by the law. It's only important to be balanced and to provide substantial grounds for interrogation through investigative judge, which minimizes the traumatization of the victim. Also, avoiding contacts between the victim and the perpetrator during any procedural actions done, also in the court hearing. Another approach that should be is supporting the victims throughout the criminal proceedings and accounting all the individual peculiarities, their state of health, their psychological state, whether they have any body limitations, etc. So it's a victim-centered approach, as well as the right to be heard. We should provide the victim, after establishing a psychological context, to be open, to let them talk, let them describe the situation and feel the support from law enforcement, not further oppression. Also, defending the dignity of the victim, protecting them from threats and intimidation from the perpetrator, as we also said. Informing about the rights and the services available that they're eligible to, but explaining these rights and procedural rights provided by the criminal procedural law has to be, it also has to be explained by the accessible language, not to go into legal lingo, because most victims are not legal people and they don't understand what the prosecutors and judges read, these lengthy, obtuse texts. They don't understand what is the way to justice through that thicket of word jungle. So specialized training for experts, not only investigator and prosecutor, but every expert that have to do with the survivors, so that people are well trained in terms of sensitive ways of communication with the victims to prevent traumatization, providing the victims the right to representation, legal representation, lawyers, free legal assistance, as I said before. Another approach is interrogations should be conducted by the same gender person, unless it's or meddling with the criminal investigation or a hindrance. Another principle is using the one-stop shop approach, not to let the victims run through office after office getting disjointed papers, but using one-stop shop, legal, social assistance. This is not an exhaustive list of approaches we are advised to use, but these are the key and most important ones. We have to account for them and design the standards that would accompany these unified approaches to provide for, in the best interest of the affected population. Thank you. Thank you, Iryna. Listening to you, I remember my conversation with other international experts as we talked about genocide. And he said, you know, how it would be easier for all the legal persons if it was deemed as ideal genocide. So you could just tick the boxes. But there are no ideal cases, and there are no ideal victims. We as a system, we work for the protocol. We want the victim to sit still, give us the ideal statement in clear text. But we're all different. We're all different people. We're all living organisms. Some people completely are oblivious of their risk that they have because their relationships in the family, people are not always ready to think that there's somebody next to them can hate them so much that they can commit a grave crime against them. They might be oblivious of that. They might be not even thinking about it. Normal person does not think so bad about people around us. We would assume people are good. So, and we should inform about that, so that people who suffer from violence in their family and be not entirely aware of that. But Iryna also bridged another topic to free legal assistance. How miserable is the percentage of people who really get it, and why? And what are the challenges that the system of free legal system faces? And that's what we're going to talk about with Natalia Verchuk, Deputy Head of Coordinational Center of Legal Assistance. Natalia, you have the floor. Thank you, Larysa. Basically, our current meeting focuses more on discussing challenges, but I would I would like to make a positive remark as well. If we compare these more recent 5 to 6 years, I'm talking about free legal systems. The number of requests from the victims to get legal assistance was miserable. I agree with Iryna. It's very small. So about 2% of people who know that they are eligible and they really use their legal representation. But if we take 2018, the system did provide legal assistance in some 200 cases. With each year, that number was growing before the large-scale invasion. It was about 2,000 in 2022. I'm only talking about secondary legal assistance. After the war, active warfare started, that percentage, of course, dropped significantly, but we still see that each year more and more people apply for legal assistance. And we understand that people request legal assistance from other law enforcement and private lawyers and NGOs. It's positive that more and more people understand that using professional legal assistance when protecting the rights in cases of gender violence, GBV, is worth and it's recommended. And if we talk about the systematic work, about a third of complaints or requests is legal assistance in helping to limit the perpetrator. In more than 80% of cases, the courts did provide the remedy, and Another positive thing that we see more and more services for free legal assistance provided to children who are victims against whom the crime against sexual freedom and integrity were committed. And I'm talking about national police, the prosecution, to provide this large-scale promo campaign regarding protection of rights of the victims, and we hope that with each year this percentage is going to increase. Talking about the problems that lawyers share, the legal community who work with the system, several aspects. First is when the domestic violence was recorded and registered as a fact. And oftentimes in administrative protocols, it's not noted what particular action from the perpetrator can be qualified as domestic violence. What specifically have they done? Just recently, my colleague helped in a case. There's a family couple who were in a divorce procedure, and the father kidnapped a child. And the mother couldn't talk to a child for a while. And when finally she asked for this permission to meet the child in the public space, so when the child said that she wants to be with the mother, the man produced an electrical shock, and the only thing that saved the woman from traumatizing her face, that she just moved away. And in the protocol of administrative offense, the police was called, the witnesses were there, but they noted that the father did not provide opportunity for the mother to see the child, through which he committed psychological violence, with no mentioning of electric shocker. Of course, the court ruled that and the court ruled that there was no domestic violence from father's side, although there were witness testimonies, everything, because the police officers didn't write anything about the electric shocker. Also, the witness of the domestic violence is the child. The child is also a victim in that case. Now, the head of national police said that 3% of cases where children file a complaint or notify about the act of domestic violence. I'm more than sure everyone who works in this area have to be more active in awareness raising, advocacy, with education, community, with children, so that people, since the age where they can be cognizant of their action, they should understand what can be done or what cannot be done, what's prohibited, not only in GBV and domestic violence. Another aspect is the witnesses and witness testimony. Sometimes it's 2 or 3 witnesses, but only one person is actually giving testimony, which is not enough. And collecting the body of evidence and collecting witness testimony is the whole area of work. Often courts dismiss evidence, photos, videos, written communication between the counterparts. And not in all cases, of course. There are very positive cases, and it's part of the part of the progress that is going on. But of course, it's several processes. When the court proceedings is concerned, there are cases where court suggests to the parties peace settlement. Of course, if the victim doesn't use free legal assistance and they don't understand the consequences, they often agree to peace settlement. Sometimes, when the court closes the case because of the lapse of time to administrative offense, does not describe the motivation in the circumstances of the case. If there is a risk of repeated offense toward the victim, then it's going to be impossible for the second time to prove that the violence was indeed systematic, not just in one instance. So we talked about imperfections of the law, in particular litigation, court cases, sanctions, and the articles that can still contain sanctions that are completely disproportional, that the technical recording of the litigation is not mandatory, which makes it difficult to appeal or go into the cassation court. Also, as my colleague said, sometimes the case is dragging for way too long, especially in criminal cases, which traumatizes the victim again and again, exhausting them emotionally and physically. And another thing that my colleagues were talking about is about courts delivering their ruling too late. Like the last or before the last day, second last day, before the appeal can be filed. And of course, when the person is not using legal assistance, a legal defendant may not know these nuances and therefore lose time necessary to go to appeal against the first court ruling. So that's one of the main challenges that we can list. Of course, there are more, but I'm not going to repeat because we talked a lot around criminal proceedings and how to prove the systematic nature of violence and the risk of violation of double punishment. But thanks to platforms for discussion like this, I think this chain from identifying the problem, looking for a solution, and finding that solution, we will go through that as fast as we can, so that people who suffer from domestic violence and GBV can have recourse to the law, and the justice will be really victim-centered by minimizing the damage that may live with that victim for months and years. Thank you, Natalia. It's important here to note how words are important and the choice of words to describe the action. Because if preventing the mother's communication to the child is perceived so abstract, but a father using electric shocker causes much more emotional reaction. And there was an interesting situation, an interesting thing that Natalia mentioned when she said that the very fact of the systemic violence is hard to prove. It's not the victims who has to prove the systemic violence. It's our job. That's what victim-centered approach means. We don't need to relegate the burden of proof onto the victim. Plus, there's a lot of references to court system and just court litigation, how judges pass their rulings. what is admissible, what is non-admissible evidence. So now it's logical step for Natalia Stefaniev, the judge of Criminal Cassation Court, as part of the Supreme Court, the president of All Ukrainian Association Women Judges of Ukraine. Nadia, the floor is yours. Thank you. Dear participants, greetings. It is logical that I would like to continue this intervention. Most people, they look into court problems and both problems and positive things after the legislation changed, and we see how the state tries to prevent domestic violence and GBV.
In 2017, we adopted new laws. Then Istanbul Convention was ratified, and also judicial system has been changing all this time as well. But we still face challenges about what materials we receive, whether the victims were provided the necessary legal assistance, whether the court can provide defense for this person, and gender-sensitive approach. Unfortunately, we cannot always deliver. We have a few types and categories on proceeding on GBV in different jurisdictions. These are criminal proceeding, administrative proceedings, on administrative offense, and also some civil cases, and also can be administrative offense if you talk about discrimination, not violence. So all these proceedings are involved when we talk about GBV. What I would like to draw your attention to how I see the development when we work on cases like this. Probably we need to focus on very specific steps. Trainings for judges first. We as judges, we have different trainings in National School for Judges and some additional trainings also. We have separate courses on domestic violence, GBV, for judges. And these courses are being developed now, and they are very useful for judges when they work on cases like this. But we don't have enough training. And I believe that we need to have specialization. I believe that it is correct that police have specialized departments which work on these specific cases. I'm not saying that we need to have judges who would work only with GBV or domestic violence, but we need to have specialized judges that whether we receive criminal case, administrative case, so that only those judges who had been trained and prepared for working in cases like this, they would receive these cases. So to have a certain pool of judges who can do that. And now, recently, we have had quite a lot of changes. We have and we understand that we do need this preparation, whether this is the first level court or higher instances. They need to understand some theoretical material of this circle of violence. They need to understand how victims should be treated, how they should be interviewed, which evidence should be included, which questions are appropriate or overruled if the defense asks something like inappropriate. Another issue that I would like to talk about, that's evidence. Yeah, so we heard that we need to collect more evidence. If it's the case of domestic violence, there are always only two people. Sometimes, unfortunately, kids are involved. And we don't have witnesses. And we always ask to provide some evidence. We have the medical examination conclusion, but we understand that not in every case we will have 3, 4 dozen of witnesses who can confirm that, yes, I saw that, because usually witnesses say that, no, I didn't see with my own eyes, I only heard that it happened, but it's not really enough for some judges. But to prove that the person is guilty, we don't need overwhelming amount of evidence. We need to really trust the evidence of the victim and what they are saying. And it has to be as a cornerstone when judges are evaluating of all the materials they have. Just last week there was a case of the middle level of physical violence, but this physical violence was a part of domestic violence, but the word of domestic violence was not even mentioned. The wife was harmed by ex-husband, and it took 3 years. So the wife went to the Court of Cassation, and the wife said that, no, he didn't beat me, and please close the case. And then the suspect stated that I want this case to be processed again. And why I talked about this case, I believe that the Court of Appeal was just. So as the victim withdrew her report, the Court of Appeal they stated that there was enough evidence and all the materials were used. The police officers were interviewed again who came to this case. And so it was proven that it happened. But all witnesses, they said that they only heard the oral fight, but they didn't see anything else. But we saw the pictures. Her face was completely covered in bruises, and some bones were broken. And having seen that, so only the judge understood that justice also has to be victim-centered. We cannot force her to prove what happened, even when she asked to close the case and when she withdrew her statement to the police. The important role of the judge is to follow the law and to be victim-centered. And we, of course, we cannot just blindly trust the statement. So, of course, we analyze every piece of evidence, but we still need to be just. And that's the reason why we need to have specialization for judges. Over the past few years, quite a few judges, they went through this course or trainings, and they know quite a lot about GBV or domestic violence. But it would be a lot more effective if for every person who committed violence, So to use this principle, so if the person committed this violence, they have to be punished, and it's inevitable that they will be punished for this violence. And about the punishment, if these punishments are fair and just, according to our legislation, I believe that we have good legislation, and we just the laws are good. We just need to follow them better. We have good restraining measures. We have special programs for offenders. I analyzed our practices, and on paper we are moving forward. So we just need to focus on practice. And the courts of higher instances, they do need to look into these cases more and protect victims, and this way bring back the trust to courts. Thank you very much, Ms. Nadia. So now we are almost at the end of our discussion, and Martin Hackett is our final speaker. So, Pravo Justice, Prosecutor UK on fighting terrorism and vulnerable groups and children, and usually our foreign experts, they either can analyze and speak about Ukraine and our system, or they can share their local experience, what they do in their own country, and what standards their country has to protect victims when we talk about sexual freedom, sexual harassment, gender-based violence, domestic violence. So the floor is yours and the choice is yours.
It's wonderful to see so many police officers and prosecutors here today, because you are really at the front line in trying to document these cases and to start investigations into these very traumatic events. What I would like to speak about is the basis of the documentation of these victims' accounts. Now, from my perspective, and this is open for discussion, there are a lot of protocols, there are a lot of academic studies in these areas as to how victims react when they are questioned about these traumatic events. But you as police officers and investigators, you as prosecutors are really the first responders to a complaint which has been made by a traumatized victim. And what you do from the very outset of that complaint shapes how that case potentially can go through the whole of the criminal justice system. Now, when you first speak to a victim in these awful circumstances, in my experience, it is important to keep things simple, to listen to that victim, and in my experience, what is beneficial not only to the victim, but for the whole of the process, from getting that victim through giving an account to the case being heard in front of judges in court, is to act at all times with humanity. Now, that is sometimes difficult. We're all practitioners, we all have pressures, we all have many, many cases that we have to deal with. But for that victim, that interaction, you are everything. That victim is looking at you for solutions, for help, for assistance. So in each and every case, I think it is necessary for us as prosecutors to make sure that we develop a rapport with that victim, that we act in a humane way towards that victim, and that will reduce the re-traumatization that that victim feels as that victim progresses through the criminal justice process. What it will also do, it will allow for the correct environment to be created around that victim in order to get the best evidence from them, because that's our job. We're trying to draw from that victim every single thing that that victim remembers about the traumatic events that they have been made subject to. Now, my experience relates to mainly prosecuting cases of sexual violence. Those have involved victims, adult victims, those have involved child victims, and those cases have also involved events where an adult comes forward to give a description of events which happened to them when they were a child. But what I found in dealing with those very difficult cases is that the same basic principles apply throughout. Keep it simple, listen to the victim, act with humanity. So what we're trying to do, we are trying to get a record from that victim of the events. Well, how do we do that? No doubt when you sit down with a victim as a first responder, as a police officer or as a prosecutor, your mind at times can be a whirl of protocols, studies, trainings that you've been on. You have to remember those processes, but what I'm asking you is to put yourself in the place of that victim. How would you like to be treated? You would like someone to express their care for you. You would like someone to ask if you had any questions. So what I encourage you to do, and what I try and do, is to make sure that from the very outset, the victim feels that they have some control over the process. Because again, if the victim feels that they have some control over the process, it is more likely that you get the best evidence from that victim and create the least trauma to that individual. So from the very outset, you're telling the victim how the process hopefully will resolve or will progress. You're trying to manage expectations as regards the progress of that victim's case throughout the criminal justice system. Because as we know, both in the UK and Ukraine, that process is never perfect. As is already been discussed, each victim is different, and each victim will react in different ways to the explanations and answers that you are giving to them. But again, in my experience, if we act with humanity, if we're open and we listen to that victim, it will maximize, it won't always work, and we have to accept that, it will maximize the chances of getting the fullest possible account from that individual. So when it comes to the documentation, you as a first responder police officer or prosecutor, in my experience, certainly in the UK, we're taking a brief description of the events from that victim. But that brief description allows us to then put in place a plan of future events in order to get the best possible capture of everything in one interview with that individual. So what you're trying to do, you're trying to contact and put in place the correct environment, a room that victim can come and give evidence in. Again, you're explaining to the victim throughout, this is what we're going to do. Do you have any questions? And listen to that victim. So putting that victim centre or room at the police station, arranging that with the victim to make sure that they can come to that place and give the best possible account to you as an investigator or prosecutor, and that account can be recorded. So we have to be aware of what that victim is going potentially to say. And in such an interview, I would be reminding the victim, we're here today to talk about this that you've previously described. It is important to remember when we go into the interview process that victim is going to be asked some fairly detailed questions about very traumatic events which have occurred to them. And I think it's important that before that interview commences, that the victim is made aware of that. And I always try and be as gentle as possible, almost apologetic. I'm really sorry, we're going to have to ask you about these traumatic events. I'll try and do it as best I can. I also will have to potentially ask you follow-up questions about those events. I'll try and do it as quickly as possible. But for the purpose of this is so that we can record what's happened to you, so that we don't have to come back again and ask you further questions. It's also important, what I found, when young children are being questioned about traumatic events, and this is certainly what we do in the UK, is to make sure in a video recording that it's on record that that child understands what it means to tell the truth. So often a child will be, will be asked, you know the difference between truth and lies. The child will no doubt say yes, and then often we put to a child, well, tell us what something that's true is. And the child will say, well, grass is green, and we'll say, yes, that is the truth. Well, tell us what a lie is. The child will say something, and then, yes. And that's establishing and listening to that child. And what we found is from that process to then go on to the events and very gently ask, you know why we're here today, to talk about these events. Can you just tell us something what you remember occurring to you? So a wholly open-ended question, and allow that child to give an open-ended account. Listen to the child. And what I usually do is, once that child's narrative account is completed, is to try and then break down the account that's being given. Can I just take you back to this point? I would say, there's something that I don't understand. I apologize for that. But can I just ask you a little bit more detail about this specific issue? I think it's also important for us as prosecutors and investigators to be aware that children will use different words to adults to describe genitalia. It's important that all those features are clarified so that we get the fullest possible account of what that child is trying to tell us, what we're trying to record, because that's the whole point of the process. So having broken down the account and then asked very gently clarification questions of the individual, it's important for us as prosecutors and investigators to be aware of the legal requirements. We're not talking about the legal requirements to the child, but we have to be aware of the legal requirements that relate to, say, in a case of rape, penetration. And we have to be prepared to ask those difficult questions in simple terms to the victim. And that goes back to our planning. How do we plan that interview as prosecutors and investigators? Because what the aim is, as I've already mentioned, is to capture at that point the fullest possible account. What I would also ask you to consider, especially in cases that relate to complaints about sexual violence, and this has been touched upon by some of the previous speakers, is that in my experience, when children or women come forward and make complaint of these terrible crimes, mostly those crimes have been committed by people who are known to that victim. And that is the same experience in the UK as what's been described here. If there is one instance of sexual violence, in my experience, there are many. It is rare within a family environment or relationship environment if a child or a woman comes forward and says, he raped me, that is a single instance of that crime. So it's important that we try and develop, if there is a course of conduct, that we try and develop and ask questions as regards that course of conduct. That is difficult when it comes to a child because a child has a different concept of the passage of time. to what we as adults have. So I've often found helpful, I would ask a child, what class at school was she in when this started? Was this Christmas or was it in the summertime? Can you remember who your friends were at the time? Just something to try and get some form of time scale as regards how long the offending behaviour has happened over. And I think we have to be aware also that the child or the victim will not remember, if it is abuse over a long period of time, they will not remember each and every specific time that this conduct occurred to them. What they remember is that this happened to me for 6 months, or this happened to me for 10 years. And it's our job, I think, to try and draw out as best we can the memory that individual has of events that have taken place over that lengthy period. What's also important as well is that one complaint from that individual can lead to a number of complaints against the same person for similar sexual conduct. I had a very traumatic case recently where I was involved in a case where a 11-year-old girl made a complaint against her grandfather. And she didn't understand what was happening. She was totally naive and ignorant, as you would expect from an 11-year-old child, as regards what her grandfather started to do to her. But she very innocently went to her mum and said, "Mum, I don't understand. Grandad has touched me today between my legs." Straight away the police got involved. But in that time, Mum spoke to other members of the family. Then daughter came forward and said, "Well, actually, 20 years ago, he did exactly the same to me." Then niece of the perpetrator came forward and said, 20 years ago, he raped me. Then the former wife of the perpetrator came forward and said, "Well, actually, throughout our relationship, he constantly raped me for 10 years, and sometimes he raped me with knife point. So we have to be prepared as investigators and prosecutors to try and break down those very complex cases and accept that victims of these terrible crimes do not come forward, first of all. They do internalize. And this is why, again, I ask you to put yourself in the position of the victim. What would you do? You've been raped. It's by a family member. You're in a very secure family environment. If you make a complaint, what will happen to you? So again, it's about trying to understand why there's been delay in the complaint and then treat that victim with humanity throughout. And as the judge said, trust the evidence of the victim when we're listening to the victim. Because what we're trying to do, and I get back to my first point, is to try and, what we call in the UK, achieve best evidence from that individual. And do that from the very beginning by creating the least possible trauma for that individual. Thank you.
Дуже дякую, Мартін, за власне.
Thank you, Martin, for very poignant and spot-on intervention. The more attentive we are to what the victim says, the more we give and we get more information. So if I remember the first metaphor reference, who are we, each of us present here, I would like to take 10 minutes of our lunchtime for questions and answers, if you have any. We can take 2 or 3 questions right now. And please give me hands up if you have a question. So I'm putting my spectacles to see you, but also give me, so there are microphones available. Give me a sign if you need. So my name is Anna. I'm the coordinator of Secretariat of Equal Opportunities Organization. Do you think banning mediation and family consultations should be banned when law enforcement social services are investigating domestic violence? Is anyone ready to answer, please? Nadia, is the question to whom? The ban of mediation and negotiations between the victim and the suspect during the start of the criminal investigation or administrative offenses being registered. That's a great question. There are international standards in that regard that basically describe, because the peace settlement, it can be part of the cases of place of residence, family disputes. That may be mediation, but violence, no, there's no time for mediation, because that's not the way. That's not the remedy in the conflict of violence. It's not gonna prevent the secondary traumatization and repeated offense. That's what I said. The violence, as a fact, has to lead to punishment. Well, proportionate, of course, and fair. And the Istanbul Convention also provides a standard to zero communication between the suspect and the victim if it's about criminal offense. Anyone, any other questions? Is everybody so hungry that the questions are postponed? You're so attentive, listening, and, you know, okay. Then another attempt. Any question, remark? Oh, there's someone over there. So I have a question to our colleague and prosecutor from Great Britain. Maybe you could share some of your approaches and maybe innovations in investigating this category of cases, or maybe in your legislation there are already recommended. So, through the lie detector, are they going to be used to work with the victim and the perpetrator? So Martin has just said, listen to the victim. I don't think he meant lie detector, but please.
Not putting victims on trial by putting them through that traumatic experience. I think what is important from again, I go back to my point, we're trying to create the best environment possible. And sometimes these very traumatized victims, I've had cases where we've had young children, when I say young children, children under the age of 10, who find it very difficult to express themselves. They're so traumatized because of the events, they've got psychological issues. We will have what are called intermediaries at court, and the intermediary is there to act as an interface between the child and the court. And often, if you ask a question in court of the victim, the intermediary will step in and say, I'm sorry, that was just too complex, that question. Simplify. So I would, and that's to protect that victim. I think that's an innovation which is really useful. I think we have protocols, and we have judges who are really determined to follow those protocols. So when victims are challenged in court by defence and prosecution advocates, the judges now are trained to make sure that those challenges are done in the correct way. So in the past, there used to be instances where victims would possibly be reduced to tears in court, which is a further huge re-traumatization of the victim. That is absolutely seen as not allowed now, and the judge, rightly in my view, will intervene to prevent any aggressive questioning of the victim, and that's how we've tried to develop things, to make it from the beginning right the way through to the final verdict of the case very victim-centric. Hope that helps.
Дуже вдячна за цю постдискусію.
Thank you for this post-discussion.